We're recording, and I'm going to start this deliberation. Ms. Bernardi, can you hear me?
Yes, I'm trying to get my video working, but I can hear you.
Do you mind if we start?
No, thank you. Please do.
Great. We're being recorded. Good morning. Today is Thursday, March 3rd, 2022, and this is a public deliberation of the Baltimore County Board of Appeals in case number CBA 22-010 in the matter of Patapsco Fields Investments, LLC, the legal owner and applicant for Patapsco Fields PUD on Johnny Cake Road and Old Stone Road, regarding a motion for reconsideration filed by the Greater Patapsco Community Association, Inc. This deliberation is being held virtually because of the coronavirus shutdown and is being recorded. My name is Deborah Dopkin, and with me are board members Sharon Bernardi and Adam Sampson. And with that, we'll proceed. This was a motion for reconsideration filed by the Community Association alleging certain matters that were raised below and alleging we erred by not addressing certain other matters. However, I don't believe the motion raised anything new or alleged anything inappropriate in terms of fraud or such other consideration on our part. Mr. Sampson, your view?
Sure. There's, as I see it, two issues raised in the motion for reconsideration. One is a procedural error because it says that I did not have the closing argument memos and therefore did not actively participate in the deliberation. And then the second just rehashes, in my view, arguments that were presented during the merits hearing and have been foreclosed by the written opinion that's been issued. With respect to the first issue, I have a few thoughts on that. Number one, closing memoranda are not evidence, they're argument. The fact that you as chair invited them to be submitted is consistent with practice in many of our cases, but not all. And as a trial lawyer of 24 years and a member of this board for 2 years, I'll reiterate that argument is not evidence. I don't believe I'm bound by anything put in argument, but we had 2 days of hearings, and then we proceeded to a deliberation in which you as the chair put forth grounds for affirming the ALJ, with which I happen to agree, and I do not believe I am obligated to reiterate, restate, or repeat anything that you said, nor am I obligated to quarrel with it simply because a party to the proceeding disagrees with the ultimate finding. So based on those couple of points, plus the fact that those notwithstanding, unanimity is not required to affirm or deny the ALJ's opinion. So even giving a charitable interpretation to the appellant's contention of a procedural error, it holds zero water because you as chair and our colleague, Ms. Bernardi, also affirmed the ALJ's decision. So I make vote number 3. And then we issued a written opinion. I signed it. So of course I adopted and agreed with its contents. And so that, I believe, provides a reason to not further address issue 1 alleging a procedural error. Then, as you stated, in shifting to the second rounds in the petition, I believe they present a high bar, which is fraud, irregularity, or mistake, none of which is present. Also, I believe there could be additional grounds where there is newly discovered evidence or a change in the law, neither of which has been raised or is applicable here. So we need not revisit our findings absent meeting that standard. And so I would concur with you, Madam Chair, that those have not been met. And so I would deny the motion for reconsideration for the reasons that you've said and which I've amplified.
And I want to add that having sat on this board now for more than a couple years, find that our members are very conscientious that you would not concur in a decision if you had not considered all the issues that were raised at the time of the hearing, and that I personally don't give any traction to an allegation that perhaps a board member was not fully engaged or aware of the issues at the time of the deliberation or at the time of signing the opinion. So I won't entertain that argument at all. And I concur with you in the result. Ms. Bernardi, where we see you, good morning.
Good morning. And I concur as well with my co-panelists. Like, we did have 2 days of deliberation, of consideration with the hearing, and we had our deliberation. We read the memoranda that were submitted, and I agree that there have not been any new arguments that were raised or things that we did not consider previously.
And if we've made a legal error, we'll let the circuit court tell us, but I don't think we have. So we are all in agreement to deny the motion for reconsideration, and we'll issue an order to that effect. Thank you for your participation. That will conclude this deliberation, and have a great day.
Thank you. Good day to both of you.
Thank you.
Bye.
Bye.